Is a medical power of attorney the same as a living will in Texas? Hi, I'm estate planning attorney Aaron Miller in Plano, Texas, and there's a lot of confusion about what the different types of advance directives are. And so today we're going to talk a little bit about the medical power of attorney, but also about the living will in Texas. In Texas, a medical power of attorney gives someone who we call an agent the authority to make medical decisions, but it's only effective if you cannot make decisions for yourself. If a doctor's determined that you cannot make decisions, then that's when this kicks in. Now, it's possible that in a couple hours from now, when the medication they've given you kicks in or when it wears off, that you'll be able to make decisions again, and then you can. It's not like you flip the switch and you never go back. The other thing that's important to know about a medical power of attorney is even though you've listed an agent, that person can have an opinion about your care, but they don't get to make any decisions until you cannot. So it's not like you're giving up any authority. You still get to make your own medical decisions. So a medical power of attorney gives someone the authority to make broad-based medical decisions. So do you do the chemo, the radiation, do the purple pill, the green pill, the orange pill, do you do the surgery or not do the surgery? And then if you don't have a living will, do you stay on life support or not? In certain circumstances. So that's what a medical power of attorney is. In Texas, we have a directive to physicians, but everybody knows it as a living will. And unlike a medical power of attorney, it doesn't have broad-based decision-making power in anybody. What it does is it tells the world if you are in a hospital, if you're on life support, if that life support's the only thing keeping you alive, if you cannot communicate, so you can't squeeze fingers, blink eyes, grunt, moan, talk to the doctors, you're out of it, and the doctors don't think that will change. If all 5 of those are true, then you're telling the world, listen, if that's the case, then I either want to be kept on life support or you want to be taken off of life support. And the thing is, you could actually put either way. It's not an automatic pull the plug. You could actually say, no, I don't want to have the plug pulled. I want to stay on life support. So the difference between this document and a medical power of attorney, you give an agent the authority to make the decisions on your living will with the medical power of attorney, but only if you don't have your own living will in place. And I recommend putting this in place because it's very important to tell your loved ones exactly what you want, because otherwise they're going to second guess and they're going to wonder if they made the right decision. I've seen this time again because we just don't know. But if we have it in black and white, we have it what mom said, we had it what our spouse said, then we know, hey, we did what they wanted, and that gives us peace. So it's very important for your family, for your loved ones, not only just to verbally tell them, but to have it documented in writing what your wishes are in that situation. If you need to have your medical power of attorney in place, or if you need to get a living will in place, or if you need any of your other estate planning documents, and if you live in Texas, give us a call.